Welcome back to the second session of our conference. This is the first session dedicated to philosophy, the only session dedicated to philosophy. The title of the panel is The Ethics of Exclusion: On What Basis, if any, may we keep others out? So this will be touching a lot of the normative issues that were already brought up in this morning's discussion, though they'll now be, if you will, developed in greater detail at greater length. I'm thrilled to have here four really interesting philosophers who all have written on this from different perspectives. We'll have Sahar Akhtar from Georgetown, Joseph Carens from the University of Toronto, Sarah Song from Berkeley, and Christopher Wellman from WashU. We'll have each of the speakers present for about 20 minutes, so they have a chance to really kind of explain what their central thoughts are. We'll go in alphabetical order. We'll be holding questions till the end, so after all four speakers have spoken, the panelists will be up here and they'll be available for answering questions. And as Giovanni pointed out earlier, there will be a plenary session at the end of the day where additional questions can also be raised. So if you don't get around to asking your questions in the Q&A at the end of this panel, there will be another opportunity later on. But for now, you'll get a chance to hear each of these four philosophers present their central thoughts on immigration and on what basis, if any, we may keep people out. Sahar, if you wouldn't mind starting.
So this is going to be a very different talk than the kind of talk that the sorts of talks that the economists gave. It's probably going to be more hypothetical, more conceptual, more abstract, maybe in some ways more annoying. Annoying. But I hope that it can bear in some shape or form on pressing policy questions that they have. So we've been asked to comment on what basis, if any, may we keep others out, and I'm actually taking this question from sort of the opposite angle. What bases are morally impermissible? I think if we can identify bases that seem certainly off limits and can understand why, we might be able to, it might present us a new way of thinking about what bases are permissible. So, but first, some terms and qualifications. I'm limiting my focus here to so-called discretionary immigrants, people who lack neither who have neither urgent nor special claims for immigration, for admission. Urgent claims might include refugees and asylum seekers and victims of persecution and significant oppression. Special claims might include dual citizens, family reunification purposes, or where there are existing relationships or particular historical relationships between certain states. And the reason I'm doing this is because I think so-called discretionary immigrants might raise a number of distinct challenges that these other immigrants do not necessarily raise. And I think there's more agreement as to what states' obligations are concerning the urgent and special claims than there are with discretionary immigrants. I'm also restricting my focus to people seeking membership, and I'm defining that as permanent residency and or citizenship. And again, I think I'm focusing my talk on this particular class of immigrants because I think people seeking permanent residence also raise distinct normative implications that may not necessarily be true or may not necessarily be raised by other forms of immigration. And finally, I'm restricting my focus to liberal states, broadly states that recognize and respect individual rights and equality and have some broad democratic principles like the rule of law. Okay, so now back to the question, or at least the way I'm taking the question. So most think that, so what bases are morally impermissible? Most think that states may not exclude people on the basis of their race. This includes most theorists writing on this subject, as well as, I think, conversations in popular and political discourse. It just seems like race is off limits. So my question is why? So here's one sort of view. So this view is what I'm calling the wrong to members view. It is a view, the proponents of this view are Michael Blake, as well as Kit Wellman. So proponents of this view argue that racial grounds are off limits because, and insofar as the wrong done to current members who share the category or the characteristics of the excluded non-members. So if state implements racial bases for excluding, the thought is that that is disrespectful to existing citizens or existing members more broadly who fall into the disfavored racial category. And I think there's something certainly right about this. I agree that such policies would be problematic for what they say about existing citizens or existing members. I also think this view is right to remind us more generally of the internal effects of immigration policies. But I also think there are some shortcomings to this view. And to start to begin to see why, this case, and this is where it gets hypothetical and potentially annoying, this case is offered by Michael Blake, and I'll offer my own annoying case in just a moment. This case is offered by Michael Blake, I'm calling it Ensuring Ethnicity, and he writes, imagine a society, an ethnically homogenous society that implements an immigration policy designed to ensure and perpetuate this ethnic makeup of society. He suggests that there isn't anything wrong by it for the simple reason that there are no existing members that would be disrespected by the policy. And I think there's something right about this, and I actually think there's something sort of intuitively, potentially permissible about this policy. But I think it might be because I don't know enough about it. I don't know enough about it, and I have a variety of questions I'd like to ask about it. So now I want you to consider this case. This one I'm calling racial ban. A wealthy state composed only of white members decides to accept people of every race except for black people. So this case shares the same structure as the previous case in that there are no existing members who will be disrespected, wronged by the policy relevant bases. But this seems intuitively very offensive to me. So if the wrong to members view doesn't explain it, and assuming that this is wrong, or at least maybe pro tanto wrong, or wrong absent justification, then what's the explanation? So this is an explanation that I'm trying to develop in a larger project, and I'm just presenting a very small bit of it here today. So the claim that states' memberships are appropriately subject to anti-discrimination norms is the part of the explanation that I want to give. So this is obvious. This might seem very obvious. And in fact, we hear claims about the discriminatory nature of immigration bases all the time. And a number of theorists also talk about discrimination. But is it a plausible view to say, is it plausible to say that states may not discriminate against non-members and on the basis of what? Is that a plausible view, and if so, why? And it's certainly plausible, it's certainly widely accepted that states may not discriminate with respect to their own members, but do they have non-discrimination duties to non-members? So, and what are the implications, and more importantly, maybe the limits of this kind of view? So, I think it'll help if by looking at the domestic context, or more specifically, associations or communities, where we think it generally is impermissible to exclude or deny on the basis of race. At least that's how I want to start it here. So there are a lot of examples for associations that are generally, whereby it would be generally wrong to exclude on such bases, but I'm going to consider large businesses. I'm going to give sort of a caricature of large businesses, and there'll be hopefully a point to that. So large businesses, imagine a large company that controls a significant market share of a major industry that implements a white-only hiring policy. I think we would probably agree that that is wrong. On the other hand, imagine take a look at marital and other romantic relationships or romantic partnerships. It's not as clear, I think, that we would consider it wrong, or at least an open question. Imagine Amanda rejects Evan's proposal in virtue of Evan's race. We might say that there's a lot that's offensive about her character. If she has poor character, we might even think that there's something reprehensible about her, depending upon her beliefs. But whether she's entitled to deny, whether she's morally permitted to deny the marriage proposal on the basis of race, still seems like it's an open question. Or, at the very least, that it depends on more information. Has there been an existing commitment? Has Amanda made a commitment to Evan? Has there been an ongoing relationship between them? In the absence of those things, I think it might be an open question. Notice, though, with large businesses, even in the absence of prior commitments, existing relationships, we would still think that it's wrong, generally wrong for them to exclude on the basis of race. So, what explains these differences? Well, there's probably a variety of things, a variety of considerations that explain why we think businesses, but not marriages, typically are generally permitted to use racial bases for exclusion. But here are two that I think are important. First, the first concerns the character or the interests for the admitting party. What are the interests relevant for seeking a member or a fellow associate in the context of marriages? Well, the interests are to cultivate and to have flourishing intimate relationships. And as such, it seems that one ought to be morally entitled to, or one is morally entitled to choose their marriage partner on the basis of characteristics of their choosing, or at least on a wide variety of characteristics. And again, I think that's still an open question. I don't think it's decisive that we don't have such prohibitions on racial grounds in marriages, but it's at least an open question. What are the interests at stake for businesses in selecting members? Well, they have to do with efficiency, productivity, achievement, and so forth. And to be sure, it depends on the kind of business and the kind of position. And it's very often the case that business goals depend on on various kinds of social relationships between their members, that the goals are better served if there is a set of shared values. But those goals are not dependent in any way on intimate relationships, at least not anything like they are in marriages. So I think that's an obvious enough distinction. The second more important distinction, though, has to do with the power of the admitting party, especially in comparison to the power of the membership-seeking party. So Amanda, she rejects Evan's marriage proposal, again, in the absence of existing relationships or prior commitments. When one rejects somebody's marriage proposal, you don't generally structure their access to other intimate possibilities. But in the case of a large company, especially in the way that I've described it, it shapes access to the employment options in the industry that it occupies. And efforts to start new businesses are met with significant startup costs, whether informal startup costs or significant entry barriers, whether informal startup costs and or formal ones, including licenses and property rights, especially intellectual property rights. So the power of the admitting party in the case of large businesses is quite significant. At least the power differential is quite significant. So these are some of the considerations, I think, that tell us why large businesses or the membership decisions undertaken in large businesses, but not necessarily those undertaken in marriage, are appropriately subject to anti-discrimination concerns. And by that, one of the things that means is that large businesses generally have duties not to discriminate or engage in actions or practices that disadvantages someone in comparison to somebody else in virtue of certain characteristics. These characteristics certainly range and they vary. They're known as prohibited grounds among discrimination theorists, they certainly vary, but they generally include socially salient identity constitutive traits. Now, there's a lot packed into both of those, and I'll only be able to briefly say something about each of them. By socially salient, I mean that it characteristic structures social interactions across a wide range of contexts. By identity constitutive, I mean a trait that is often important to the way one forges values and maybe even important to their conception of their self. Common examples include disability, gender, race, sexual orientation, religion, ethnicity. There's a lot of disagreement in the discrimination theory, so I'm kind of going to be beset by the same problems that beset that whole literature. And one of the biggest sources of disagreement concerns what the wrong of discrimination is, and I'm not going to be able to say really anything about that here, though I will in the larger project. What the wrong of discrimination is, it varies quite a bit. I'm drawn to views that say that the wrong of discrimination is that it demeans the object or it disrespects them. Okay, so when we think about those two considerations, those that I raised, the power and the interest of the admitting party, so it seems like marriages stand on one sort of end of the spectrum and large businesses stand on the other. And there's probably a lot of associations and communities that fall somewhere in between, including religious organizations, social clubs, cultural groups. I don't think we need to examine all of these groups, all of these kinds of associations to analyze states in the light of some of the considerations that I've given. It seems that states are not only much closer to large businesses than they are to marriages, but that states would be even way outside, fall much further from marriages than would large businesses, even under the really, the bad caricature of a large business that I gave. In terms of the interests at stake for state membership, well, they're not intimate or personal or even necessarily social. The importance of a shared set of values in liberal states, I don't mean to minimize that. Values including mutual respect, autonomy, equality. But these values are arguably somewhat thin, and in any case, one's ability to embrace them or perhaps more aptly respect them, I don't believe depends on one's race. Just like whatever corporate values are present in a company will not depend on one's race. As to the second more significant issue, state controls access to a range of important life-shaping opportunities, so not just employment, but broader economic opportunities, geographic, political, social opportunities, even personal options. And efforts to start a new state, well, that's sort of insurmountable because states control all of the habitable territory on Earth, and you're not going to be able to secede at will from a state. So, as such, the power differential between states and those seeking, or a state and those seeking membership in the state is considerable. Now, I don't think this provides decisive reason to think states are subject to these duties, but I think it provides some reason. Okay, so now how does this kind of general idea explain potential intuitions that we might have had about these cases? So, first, ethnicity and race are incredibly fraught, contestable notions, and I'm not going to give any definitions of those here. Having said that, one might think that ethnicity is more closely related to cultural practices, including languages, and there may be reasons to object to excluding somebody on those grounds, excluding an immigrant on those grounds, but it doesn't seem objectionable in the same way as racial grounds do. Language, for instance, may not be identity constitutive or socially salient in the same way. A more significant difference, potential difference between the two cases, is that what we know about ensuring ethnicity is that it's an immigration policy designed to ensure and perpetuate the ethnic makeup of society. Well, we might think that the state is seeking to preserve a vulnerable ethnic or even racial group, and as such, it might be similar to what discrimination theorists referred to as protected groups. So protected groups, just like prohibited grounds, they vary, but once we identify, or once a prohibited ground category is identified, protected groups are those groups falling into the category that are vulnerable in some sense, typically because they've experienced abiding relative disadvantages. So if the category is gender, women as opposed to men might be a protected group. Something that often sets protected groups apart is that they may not just be prohibited grounds for discrimination, but they might also have special moral rights and privileges. And insofar as we think of the first state, the state in the first policy is composed of a vulnerable ethnic group, we may think that it too should exclude certain kinds, it too should have certain kinds of exclusion rights that other groups are not entitled to. Maybe the most significant reason for the difference between these cases is that no one is singled out in ensuring ethnicity. So I'm taking this straight from the author Michael Blake. Seems like we're meant to presume, or we're at least potentially meant to presume, that the immigration policy admits people that share the general or share the ethnicity, but generally excludes everybody else. So it doesn't single out anybody for exclusion. The policy, though, under racial bans is sort of a paradigm case of direct discrimination, or discrimination that picks out certain people for less favorable treatment than others. And it's almost a caricature of a direct discrimination case. So I've said something about the wrong to members view. I'd like to just briefly comment on the idea of open borders. And there's no one, I guess, completely accepted characterization or formulation of this view. I am taking this largely from Joseph Carens' work, and he can correct me if I've represented it inaccurately. That the idea is just as people are free to move within a state, they should generally be free to move across states, aside from security restrictions, as well as minimal restrictions protecting property rights and enhancing everyone's freedom of movement, so traffic and safety regulations. So unlike the wrong to members view, this view can say what is wrong with the policy and racial ban. But it might also mean that all of these cases are also wrong. And I am not clear that they are wrong. At least it seems to me that we need to know more about these policies. And if you're an open borders proponent, I'm not going to convince you that these are acceptable or potentially acceptable. But if you're like me and you're not sure, you're going to want to know more information about them. And I'm not up here telling you that the anti-discrimination framework can tell us decisively whether these are right or wrong. But what they might be able to do is help us pick out what we need to know in order to tell whether they're right or wrong. So, for example, insofar as we know, none of these cases and racial preference is hidden. That's okay. We'll just confine ourselves to the first three. None of these cases excludes a vulnerable group. Additionally, none of these cases singles out, insofar as we know, none of these cases singles out a particular group for exclusion. So those are just some of the differences. And I welcome thoughts about these cases or others. And at that, I'll leave it. Thank you so much.
So it's great to be here. I really like the idea of bringing together people from different disciplines and talking across these barriers. I like the fact that the economists were engaging with philosophy, and I wish I could reciprocate here. I'm not. That's just not part of the argument for the most part. So we were asked to talk about exclusion as it relates to immigration, and so I wanted to start by just drawing attention to the different ways in which one could understand exclusion in relation to immigration. So one important thing to see is that many forms of exclusion could apply to immigrants who are already present. So think about the economic and social marginalization of legally admitted immigrants, Or think about limiting the legal rights of temporary workers, would be another form of exclusion. Or think about the pursuit of those without authorization. These are all ways in which people who are already inside can be excluded. I'll just take a minute on that last one about people who are, think about people, the term I use is irregular migrants. People who like them call them undocumented, people who don't like them call them illegal aliens. So I tried to pick a term which doesn't presuppose the position. But you can object to irregular migrants as well. Anyway, there are people who settled without the state's authorization. So the first thing to see is that even people who have settled without the authorization of the state are morally and legally entitled to have their basic human rights protected. You can't shoot someone just because she doesn't have a visa. But irregular migrants often cannot exercise their legal rights effectively because if they do so, they'll be exposed to the immigration authorities and deported. So if we take the protection of human rights seriously, we should create a firewall between immigration enforcement on the one hand and the protection of human rights on the other, and we should prohibit those who are responsible for the latter, for protecting human rights, say ordinary police, emergency medical personnel, and so on, prohibit them from communicating with those responsible for enforcing immigration laws, just the opposite of what we actually do sometimes. So some people are skeptical about the feasibility of such a firewall, but I contend many liberal democratic states already create firewalls in many different areas through privacy legislation and other rules that prevent public officials in one department from gaining access to information that officials in another department possess. So the issue is not administrative feasibility, but rather the extent of our commitment, our political will to protect important basic rights. And I'll just add that, in my view, over time, even people who've settled without authorization become members of society in which they live, and that membership should be recognized by granting them legal status after they have been present for an extended period. Now, I know not everyone will accept these claims, and I'm happy to pursue them further in the discussion, but I just mention them as ways of thinking about how the exclusion that exists of people who are already present and how one might combat that exclusion. But now I want to move on to the more controversial parts of my talk. Discussions like this one always take place against a background of presuppositions. And there can be good reasons for adopting different presuppositions for different purposes. Economists, for example, sometimes assume a background of perfect competition to clarify the logic of certain economic arrangements, and then sometimes assume more realistic background conditions for more immediate policy purposes or for other reasons. And we do the same in political theory, but not always so self-consciously. Sometimes we adopt presuppositions about values, sometimes about the political and economic background circumstances of our discussion. And again, the point here is to say not that there's a right or wrong, but to be conscious of one's presuppositions and give some reasons for it, and then operate within the framework in a particular discussion. So in my talk, I'm going to start by taking as one presupposition what I call the conventional moral view about immigration. Namely, and that is that states have a moral right to control admissions, and so to exclude more or less whomever they want. That's kind of the conventional view, but we already recognize some limits to this conventional view, at least in principle. If we acknowledge, as most people do, again, in principle, and most people, always have to say these days, most people acknowledge we should not discriminate on the basis of race, ethnicity, religion in our admissions decisions. Now, Sahar was giving us some reasons for that. But most people recognize there's something problematic about such forms of discrimination. Most people recognize that immediate family members have a special kind of claim for admission that other people don't. Most people recognize that we have some obligation to take in refugees, so on. Again, Sahar mentioned both of those categories. So in my talk, what I want to do is to expand a bit these, the category that we think of in the context of refugees and our obligations to refugees in the first part of the talk, and in the second part of the talk, I want to challenge that conventional assumption. So I presuppose it at the beginning, and if you think about refugees, it may seem odd to presuppose that conventional view, but actually the whole problem of refugees only emerges in a context in which you had the conventional view. If you had open borders, you wouldn't have a problem with refugees. They could go where they needed, right? So that thinking about refugees as a distinct problem, and this is one of the reasons why you don't want to always just take what you think is absolutely right, because to think about the problem of refugees has to presuppose a context in which states are normally entitled to admit or exclude on the basis of their own values and criteria. Okay. So, even if we accept this conventional view about the state's right to exercise discretionary control, everyone, and these days I know you can never say everyone, it's rash to assume these views are shared by everyone, but let's say those who present themselves as committed to liberal democracy, most of those people recognize that refugees have a special claim. And we have come, I'm going to use the we here collectively, we've come to this view because of the way we responded, or actually the way we failed to respond, to the plight of Jewish refugees fleeing the Nazis in the 1930s. We kept most of them out. In one famous case, the United States and Canada actually turned away a boatload of Jewish refugees who had made it to North America. And in many cases, states prevented Jews from coming in the first place by denying them visas and putting other obstacles in their paths. And the reasons for refusing to admit Jewish refugees were the same sorts of reasons that you hear today for refusing admittance to refugees. But we've got our own problems, it's too expensive, some may be subversives. One prominent government official worried explicitly about Nazi saboteurs and spies who might pretend to be refugees to gain entrance to the United States. Others worried about their being communists. And after World War II, people in liberal democratic states recognized that this exclusion of Jewish refugees had been a terrible moral failure on our part, and we vowed never to let it happen again. So along with other states, we created an international refugee regime that guarantees that people cannot be returned to a place where they'll be subject to persecution. But now we are failing once again to provide refugees with the protection that they need. Rich states have undermined the refugee regime with visa controls and carrier sanctions that make it difficult for refugees to make it to our shore. Now, here's an obvious point, but it's still one worth making explicitly. You cannot claim to have addressed the refugee problem if you set up a regime to protect refugees that you prevent the refugees from using. I mean, that's what we've done, at least with respect to many refugees. Well, in addition to its inaccessibility, the current refugee regime is deeply inadequate in other ways, mainly by the way it assigns responsibility for taking care of refugees. So, what do refugees need and who should provide it? Those are the basic questions. Well, first of all, what they need is, initially, at first, a safe haven, someplace where their lives won't be in danger and their basic human rights will be respected. And for these purposes, refugee camps make sense if they're properly organized and supported, but it is not reasonable to expect people to live their entire lives in a refugee camp. But that is what we do today. Millions of refugees spend long years of their lives, sometimes their entire lifetimes, in camps with little or no education for the children, limited or no economic opportunities for the adults, and extreme physical danger, especially for the women. This is not an acceptable way to treat people in desperate need. Refugees who cannot return home within a reasonable period need a new home, somewhere where they can live a normal life. So, that's what they need. Who should provide refugees with what they need? Well, it may be reasonable to expect neighboring states to provide the initial safe haven, at least so long as those states don't have to bear the financial cost of doing so, in addition to the social dislocation that's inevitably entailed. But there's no reason to expect the neighboring states to provide refugees with a new home if that's what they need. That is a responsibility that ought to be shared by all states. And that's precisely where we are failing today. Turkey has taken in millions of refugees. Lebanon, a country of only a few million people, has taken in 1 million, almost a quarter of its population. Jordan has taken in millions as well, and there are other examples. Now, these states are not responsible for the fact that the people became refugees in the first place. So it is just not reasonable to expect them to be the only ones to provide the refugees with the new homes that they need. And we have failed terribly to meet that responsibility. Now, sometimes people say, well, taking in large numbers of refugees is just too much to ask of us. But, you know, several states, including the United States and Canada, did much better after the war in Vietnam, taking in large numbers of refugees. And Germany took in 1 million recently. So there are different ways to think about how the responsibility for resettling refugees should be shared. Obviously, the size of the existing population of a state is one important consideration. You can't expect the Netherlands to take in as many as the United States and so on. And there are many other considerations. But whatever would be a fair way of sharing that responsibility, you posit it, and whatever would be a fair way, it's just not plausible to claim that most rich states today are doing their fair share in this regard. And the question that we ought to be asking ourselves, but which we almost never do, is what do we imagine will happen to these people if we do not take them in? And why do we think it is acceptable to foist the responsibility off on the neighboring states and to shut our eyes to the limited lives that so many people will face when we refuse to take them in? So that's the refugees. And that's within the assumption that states normally have the right to control, but refugees as a special case, people with a specially urgent claim. But now I want to challenge the conventional view. So here's the case. Apologies to those who have heard it before. Borders have guards, and the guards have guns. Now that's an obvious fact of political life, but it's one that's easily hidden from view, at least from the view of those of us who are citizens of affluent democracies. If we see the guards at all, we find them reassuring. We think of them as there to protect us, rather than to keep us out. But to Africans and Afghans in small leaky vessels seeking to avoid patrol boats while they cross the water to southern Europe or to Australia, to Mexicans who are willing to risk death from heat and exposure in the Arizona desert to evade the fences and the border controls, it's quite different. To these people, the borders, the guards, the guns are all too apparent. Their goal of exclusion, all too real. So what justifies the use of force against such people? I mean, maybe borders and guards can be justified as a way of keeping out terrorists and armed invaders and criminals, but most of those trying to get in are not like that. We know that. They're ordinary, peaceful people, seeking only the opportunity to build decent and secure lives for themselves and their families. On what moral grounds can we deny entry to these sorts of people? What gives anyone the right to point guns at them? Now, to many people, the answer to this question will be obvious. Well, the power to admit or exclude non-citizens is inherent in sovereignty. It's essential for any political community that seeks to exercise self-determination. It has to be able to exclude people like this. Every state has the legal, people will say, every state has the legal and moral right to exercise control over admissions in pursuit of its own national interest and of the common good of the members of its community, even if that means denying entry to peaceful, needy foreigners. States can choose to be generous in admitting immigrants, but in most cases, at least, they're under no moral obligation to do so. That's the conventional view. And I want to challenge that view. In principle, in my view, borders should generally be open, and people should normally be free to leave their country of origin and settle wherever they choose. I think this critique of exclusion has particular force with respect to restrictions on movement from developing states to rich states, but it applies more generally. So here's the key. In many ways, citizenship in Western democracies is the modern equivalent of feudal class privilege. It's an inherited status that greatly enhances one's life chances. To be born a citizen of a rich state in Europe or North America is like being born into the nobility in the Middle Ages, even if many of us belong to the lesser nobility. To be born a citizen of a poor country in Asia or Africa is like being born into the peasantry, even if there are a few rich peasants, and some peasants manage to gain entry to the nobility. Well, like feudal birthright privileges, contemporary social arrangements not only grant greater advantages on the basis of birth, but they entrench these advantages by legally restricting mobility, making it extremely difficult for those born into a socially disadvantaged position to overcome that disadvantage, no matter how talented they are or how hard they work. And like feudal practices, these contemporary social arrangements are hard to justify when you think about them closely. Reformers in the late Middle Ages objected to the way feudalism restricted freedom, including the freedom of individuals to move from one place to another in search of a better life. And that constraint, was crucial to the maintenance of the feudal system. Well, modern practices of state control over borders tie people to the land of their birth almost as effectively. Limiting entry to rich democratic states is a crucial mechanism for protecting a birthright privilege. And if the feudal practices protecting birthright privileges were wrong, what justifies the modern ones? There are millions of people today in poor states who long for the freedom and economic opportunity that they could find in Europe and North America. Many take great risks to come, and if the borders were open, millions more would move. The exclusion of so many poor and desperate people seems hard to justify from a perspective that takes seriously the claim of all individuals to be regarded as free and equal moral persons. which I take to be a fundamental assumption of moral reflection. Now, some will object that open borders would be contrary to our interests. One can challenge that on economic grounds, as Michael and others have. But suppose they're right. Suppose it is contrary to our interests. If we want to act ethically, we have to give reasons for our institutions and practices, and those reasons have to take a certain form. It's never enough to justify a set of social arrangements governing human beings to say, well, these arrangements are good for us, without regard for others, whoever the us may be. We have to appeal to principles and arguments that take everyone's interest into account or explain why the social arrangements are reasonable and fair to everyone who is subject to them. That's the general requirement. You know, the New Yorker once had a cartoon that seems appropriate to mention here. It shows two kings talking to one another. And the first one says to the other, well, monarchy may not be the best form of government in principle, but it has always seemed the best form of government for me. And I'm afraid that those of us who live in rich states today are a lot like that king. The way the world is organized may be hard to justify in principle, but it's good for us. Well, I have no illusions about the likelihood that rich states will actually open their borders. The primary motivation for this argument is my sense that it is of vital importance to gain a critical perspective on the ways in which our collective choices are constrained, even when we can't do anything right here and now to change those constraints. Social institutions and practices may be deeply unjust, and yet so firmly established that for practical purposes they have to be taken as background givens in deciding how to act in the world at a particular moment in time. For example, feudalism and slavery were social arrangements that were deeply entrenched in places in the past. In those contexts, there was no real hope of transcending them in a foreseeable future, but criticism was still appropriate. So even if we have to take such arrangements as givens for purposes of immediate action in a particular context, what is to be done today and tomorrow, we should not forget about our assessment of their fundamental character. Otherwise, we wind up legitimating what should only be endured. Of course, most people in democratic states think the institutions they inhabit have nothing in common with feudalism and slavery from a normative perspective. The social arrangements of democratic states they suppose are just. Well, nearly so. And it's precisely that complacency that the open borders argument is intended to undermine. For I imagine, or at least I hope, that in a century or two, people will look back upon our world with bafflement and shock. And just as we wonder about the moral blindness of feudal aristocrats and southern slave owners, future generations may ask themselves how Democrats today could have possibly failed to see the deep injustice of a world so starkly divided between haves and have-nots, why we felt so complacent about this division, so unwilling to do what we could to change it. The argument for open borders provides one way of bringing this deep injustice of the modern world into view. Now, it's only a partial perspective, because even if borders were open, that would not address all the underlying injustices that make people want to move. Still, it's a useful perspective, because our responsibility for keeping people from immigrating is clear and direct, whereas our responsibility for poverty and oppression elsewhere often is not as obvious, at least to many people. We do have to use overt force to prevent people from moving. We need borders with barriers and guards with guns to keep out people whose only goal is to work hard to build a decent life for themselves and their children. And that is something we could change. At the least, we could let many more people in. Our refusal to do so is a choice that we make, and one that keeps many of them from having a chance at a decent life. Thank you.
So this panel has been asked to consider the question, on what basis, if any, may we keep others out? Who's the we in this question? It's commonplace to think of the we as members or citizens of particular countries, and its political institutions, public officials that claim to rule in the name of citizens. I think to answer this question, we need to address at least two other questions. And so I want to focus on these two questions in my talk. Is special or preferential treatment of members over non-members justified? And is the power that we as members of modern states exercise over borders justifiable? So the first, radical cosmopolitans say no. And when I say radical, I don't mean thoughtless, because Michael Clemens said he's been accused of being a thoughtless cosmopolitan. I think radical cosmopolitans are very thoughtful. And they argue that if we accept the moral equality of all human beings, why shouldn't people be free to move across borders if they wish? The case for open borders, which Joseph Carens just powerfully made, is strengthened by a distributive objection. It's a matter of luck whether one is born a citizen of a poor or wealthy country, yet border controls help sustain global inequalities by preventing people from poorer societies from moving to richer ones. Like being born into a wealthy family, citizenship acquired by being born in the territory of or to parents of who are citizens of wealthy countries is a matter of luck. To borrow a phrase from John Rawls, it's so arbitrary from a moral point of view, yet strongly determines our prospects in life. So I agree with that the distribution of citizenship is morally arbitrary, but citizenship is nonetheless morally significant. In my forthcoming book on immigration, I develop a normative theory of immigration rooted in an ethic of membership. An ethic of membership holds that we have particular obligations in virtue of our membership in political communities. And this ethic of membership is based on the idea of associative obligations, which Samuel Scheffler and others have written about. So consider your relationship to family and friends. We regard the needs, interests, and desires of our friends and family as providing us with reasons to perform actions that we do not have comparable reason to perform for others. Associative obligations extend to our membership in groups. We find membership in religious communities, ethnic associations, sports clubs, the Girl Scouts and Boy Scouts to be not just instrumentally valuable, but rewarding in their own right. To value membership in a group just is to regard that membership as giving us reasons to do things on behalf of the group and to help sustain the purposes of the group. In the case of relationship with family and friends, we look to their needs, interests, and desires as guides to action. In the case of groups, we look to group norms that play the role of communicating the needs, interests, and desires of the group. So the idea of associative obligations extends, I argue, to membership in political communities. But what kind of relationship do compatriots have to one another that could give rise to special obligations? After all, the vast majority of our compatriots are strangers to us, so how can it be that we actually have particular obligations to them? What are the ties that bind us to fellow compatriots? So some argue that we should regard political membership and its obligations as grounded in consent. I'm here thinking of a book by Peter Schuck and Roger Smith, where they seek to revive the notion of consent-based membership. But this runs into familiar problems that most people haven't given their consent to the countries they happen to be born citizens of. Another answer that's been very politically potent comes from nationalists, theorists of nationalism, who contend that political membership is based on shared national identity. As the political theorist David Miller argues, with national identity comes a kind of solidarity that's lacking if one looks just at economic and political relationships. People feel emotionally attached to one another because they share this identity. So nationalist conceptions have proven to be a potent basis for defining political community. As I'll discuss later in my talk, the nationalist view suffers from some serious problems. I think problems that Michael Clemens' talk gets at when he's analogizing migration barriers with racism and racial exclusions. Okay, so for now, I want to emphasize that adopting the idea of membership-based obligations does not mean that we have no obligations to those outside our circles of membership. We can prioritize the interests of compatriots, but our membership obligations must be balanced against our universal obligations to all of humanity. I call this position moderate cosmopolitanism. And of course, there's a genuine tension between the particularist claim about political responsibility and the universalist claim about moral equality, which will never be eliminated, but it can be managed and reduced by recognizing that they're mutually constraining and that each places limits on how the other value may be pursued. When it comes to immigration, I argue that what's required is not open borders or closed borders, but open doors, coupled with robust development assistance to poor countries. Then the question becomes, for public political debate, open to whom? And I'll return to this question at the end of my talk. But moving on, to answer the question on what basis may we keep others out, the other question we need to address is whether state control over immigration is justifiable. It's a family of views that Joe Carens referred to as the conventional moral view. And I want to kind of dig underneath this view to think about how we might, different attempts to justify this conventional view. These are some of the prominent accounts on offer in the philosophical literature. I'll briefly examine the first. I'm assuming that Kit will talk about his own view, and then we can discuss some of the others that I won't have time to discuss in the Q&A if you like. And I'm going to focus on the idea of collective self-determination. So what, if anything, justifies state control over immigration? Perhaps the most prominent answer offered by theorists, and certainly one that resonates with public political discourse, is an account based on the value of cultural and national identity. Michael Walzer, in his book Spheres of Justice, was one of the first theorists to explicitly examine the good of membership in debates about distributive justice. He says political membership is perhaps the most important good because historically it's determined access to rights. Before we can have civil, political, social, economic rights, we need membership in a political community. Walzer conceives of the political community as a national family. Like a national family, a fundamental imperative of the state is to preserve a culturally distinctive way of life. He suggests that state control over immigration rests on this cultural imperative. And this is the quote, I've provided, the distinctiveness of cultures and groups depends upon closure. If this distinctiveness is a value, as most people seem to believe, then closure must be permitted somewhere. At some level of political organization, something like the sovereign state must take shape and claim the authority to make its own admissions policy, to control and sometimes restrain the flow of immigrants. The we in Walzer's argument is a distinctive cultural group. The state's right to control immigration derives from a cultural group's right of cultural preservation. David Miller has developed the cultural argument for a state's right to control immigration in explicitly nationalist terms. The state's right to control immigration is said to derive from a nation's right to control its own territory. And according to Miller, there's a two-way interaction between territory and the culture of the people who live on it. First, the national culture adapts to the territory, whether the climate's hot or cold, whether the land is landlocked or open to the sea, will encourage the development of certain customs and discourage others. Second, the territory itself will be shaped according to the cultural priorities of the people who live on it. Cultural priorities of the people who labor on the land. So labor not only adds economic value, but also endows the land with cultural meaning. So essentially, Miller offers a Lockean argument. Because members of the nation add value and meaning by mixing their labor with the land, the nation as a whole has a legitimate claim to the enhanced value that the territory now has. I think that Walzer and Miller's cultural and nationalist arguments suffer from several problems, which I detail in my book. I'll just highlight two here. First, it permits racial and ethnic exclusions insofar as racial and ethnic identities are regarded as central to national identity. Miller, to be clear, explicitly rejects racial exclusions for reasons very similar to the ones that Sahar went over in her talk. But historically, discourses of national identity have tended to exclude and include prospective migrants on the basis of race, ethnicity, religion, national origin. Think of the Chinese Exclusion Act, the National Origins Quota System, or Trump's Muslim ban. In contrast to Miller, and I think this is really interesting, Walzer bites the bullet. In discussing the White Australia policy, he accepts racial exclusion as an implication of a cultural argument. In the first half of the 20th century, the Australian government sought to exclude Chinese migrants in order to keep Australia white. Walzer says that Australian citizens faced one of two choices when confronted with non-white refugees seeking admission. On the one hand, Australians could meet the duty of mutual aid to refugees either by admitting them, or on the other, giving them some of their land to the needy strangers to establish a separate community, thereby preserving a white Australia. Walzer gives weight to the refugees' claim to enter, but he takes just as seriously white Australians' claim to keep Australia white. A second problem with the cultural argument has to do with who is doing the laboring. The work is performed by individuals, not the nation, Indeed, the laborers are often non-citizen migrants who are not members. So why should the nation gain rights over the territory and not the particular individuals who actually perform the labor? If there is a compelling argument for a state's right to control immigration, I believe it rests on the idea of collective self-determination, as Walzer and Miller do, but the collective, the we, is defined in terms of participation in shared institutions, not in terms of a cultural identity. Although members of a political community are strangers to one another, they develop attachments, loyalty to the community through a shared history of cooperating together. So, what is collective self-determination? It's a claim of a people to rule itself. The first article of the UN Charter states that a central purpose of the UN is to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. Article 1 of the International Covenant on Civil and Political Rights declares all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. So let me just briefly sketch my self-determination argument for the state's right to control immigration. First, a people has the right of collective self-determination. What is a people? It's a group of individuals that aspires to collective self-rule, has the capacity to establish and maintain political institutions, and has a history of political cooperation and participation. Political cooperation can take the form of political mobilization by a group that aspires to statehood or sub-state arrangements through which they can exercise self-determination. Political cooperation may also take the form of participating in already established state institutions. So Americans are a people not in virtue of a shared cultural identity, as nationalists would argue, but in virtue of a shared history of cooperating and participating together in common institutions. The right of collective self-determination derives from the basic interests of individuals in having some degree of control over their lives, but collective self-determination is a collective right in two senses. First, the agent is a collective agent, a people, as I've just discussed. And second, collective self-determination is a collective good. The interest in question is not the interests of individuals, but as individuals as members of a collective. And it enables a distinctive kind of freedom, political freedom. The second claim is that to exercise self-determination on behalf of the people it represents, the state requires territorial rights, which include the right of territorial jurisdiction, to make and enforce laws throughout the territory, the right to control and use resources in the territory, and the right to control the movement of people and goods into and within the territory. Why should we think of immigration control in particular as fundamental to collective self-determination? After all, a state could exercise the right of territorial jurisdiction, control over land and resources, without also controlling the movement of people on the land. I actually don't know Joe's view about rights of territorial jurisdiction, but he might say a state can exercise control over land and resources. It just can't control who comes in and who goes out, so anyone who wants to be a member can be a member. I think there are two kinds of arguments that we can make in thinking about why immigration control in particular is fundamental to collective self-determination. And the first is concerned with the effects of immigration on the pursuit of particular goods that members of the political community value. Some focus on the economic impact, such as the fiscal costs and benefits of immigration and the effects of immigration on the labor market, which the morning panel and another panel this afternoon will talk about. And I think that in normative debates, we often make assumptions about the effects of immigration, and we look to economists, and it was really helpful to hear what economists can and cannot measure and what we can and cannot know. So others worry about the political impact of immigration, on the effects of immigration on social trust and on public support for social welfare programs. And still others are concerned, and we hear a lot about this in contemporary discourse, the cultural impact of immigration on the collective self that is the subject of self-determination. A second argument, and in my view, a stronger set of arguments about the importance of immigration control for collective self-determination focuses on fundamental rights rather than particular goods. So what rights are at stake when it comes to immigration? And here it's helpful to contrast between two alternative rights-based accounts before saying something about my own. So both Kit Wellman and Michael Blake offer deontic arguments for the state's right to control immigration. Wellman appeals to the individual right of freedom of association, relying on analogies with marriage and golf clubs. Just as an individual has a vision of what sort of marriage or what sort of golf club she wants to have, citizens have a vision of the political association they want to have and should be able to exclude people as they wish. I think he misses what's distinctive about political community. It's a group bound together by participation in shared institutions rather than simply by the shared understandings of its members. Michael Blake recognizes the distinctiveness of the state as a jurisdictional and institutional project, but he doesn't really engage with the value of collective self-determination. So he grounds the state's right to control immigration on the individual right to avoid unwanted obligations. The would-be immigrant acts to impose a set of obligations on current residents when she crosses into the territory. And he uses Judith Thompson's example of the violinist. You wake up one morning, you've involuntarily been attached to a violinist who now depends on you for survival. I couldn't resist showing you these young violinists. I was at this concert with my daughters and they're young violin, but I would voluntarily attached to her. Anyway. Michael Blake analogizes the violinist with the would-be immigrant. Both the violinist and the would-be immigrant commit the same wrong. They impose on you an obligation that you have no independent obligation to accept being so obliged. I think what's missing from Blake's account is collective self-determination. What makes political community a distinctive and valuable form of association is not only that we're coerced by it, and not only that it's a scheme of cooperation, economic and social cooperation that provides basic goods and services, but that it enables members to exercise some degree of control over their collective life. So a key part of the value of political membership is that it makes collective self-determination possible. When would-be immigrants enter or remain in a territory without authorization, they sidestep this collective process by which members of the community make decisions about membership. And this violates the right of collective self-determination itself. So my talk is drawn from my forthcoming book. It's just been a big commercial. The book develops what I call an intermediate ethical position that aims to take seriously both the claims of receiving countries and the claims of prospective migrants. I agree that I argue that political membership is morally significant, even if its distribution is morally arbitrary. Political membership grounds particular rights and obligations, and a government may show some partiality toward the interests of its members. Yet we also have universal obligations to those outside our borders. Where prospective migrants have urgent reasons to move, as in the case of refugees and other necessitous migrants, their interests may trump the less weighty interests of members. On my moderate cosmopolitan approach, what's required is not open or closed borders, but open doors. But to whom should the doors be open? And very briefly in closing, because I only have a couple minutes left, I want to consider the substance of immigration policy. The question on what basis may we keep others out invites us to consider not only the normative grounds upon which members of political communities can exclude non-members, but also the particular reasons for including or excluding prospective migrants, which Sahar, Akhtar, and Joseph Carens have also touched on. So who must be included and who may be excluded? Who must be included, a category we might call obligatory admissions, following Joe Carens and Michael Blake and others. So refugees and asylum seekers, other necessitous migrants who are forcibly displaced from their countries but don't meet the definition of refugee set forth in international and domestic law. We might think of climate change refugees as an example of those who don't fit the conventional definition of refugee. I also argue, I have a chapter of my book devoted to family of current members, and there's a really important debate to be had about who counts as family. Now, same-sex partners, same-sex spouses are included by law in who counts as family. What about grandparents, aunts and uncles? Canadian law, there was a commission that recommended this reform and said, what about best friends? Right, if you don't have and so it gets at the grounds of, if you don't have a family member or you're estranged from your family and you want to sponsor your best friend, why shouldn't you be able to? So we can think about how we might push the boundaries of that category. Who may be excluded? So discretionary admissions and I talk in the book about criteria of exclusion and criteria of admission. Just very briefly on exclusion, prospective migrants who may pose a genuine threat to national security or public health. And I want to point out here that I think this is a legitimate ground of exclusion, but the danger is the abuse of the use of this criterion. It's been abused. Just think of the Trump administration's defense of the travel ban. It's named in the name of national security. And I want to say that we want to be careful about the dangers of abusing it, but its principled use as a basis of exclusion is morally defensible. So the challenge is to determine what constitutes a genuine threat to national security. The economic impact of immigration on current members, I think, is it's morally relevant and an important part of the debate. And this is where we look to economists about what are the fiscal impacts of immigration, what are the impacts on the labor market. And I think if you're a proponent of open borders, we don't need to engage in those debates because anyone who wishes to come can come. I think if you take the position that I have that says the ethic of membership is important, then we actually want to talk about we really care about the effects of immigration on members. Cultural impact, I'm really sympathetic to the line of argument that Sahar Akhtar is developing about why not racial and ethnic exclusion. But I think the other side of the coin, so we think about criteria of excluding, we might think of criteria of admitting. Can we prioritize on the basis of ethnicity or religion? Under certain circumstances, I argue that you can. And we might look to some historical examples. And I'm out of time, so I'm happy to go into more of this in the Q&A, but this sort of gives you a sense of how we might engage in the debate about the substance of immigration policy. Thank you.
And last but not least, Kid Wellman. Thank you.
So thank you, Daniel, very much for including me in this great conference. I don't leave the house much, but I definitely was willing to hop on a plane last night and come for this. I'm huge fans of my fellow panelists. It's great, as Joe said, to be at a conference that's interdisciplinary like this. And most of all, I think it's important that we attend to something which is of such pressing, unfortunately, significance right now. It's also, I must confess, a very important personal vindication for me to be invited to come speak at NYU. I'm not sure that I leave the world, but I'm pretty sure I leave the room in rejections from NYU. I grew up a huge fan of Woody Allen, and I wasn't a great high school student, but I fantasized about coming to New York and being a movie maker. And evidently my essay in my college application didn't impress the people at NYU, and I was denied admission to NYU as an undergrad. So I went to North Carolina and did a lot better as a college student than as a high school student. Developed an interest in philosophy and applied to the PhD program in philosophy at NYU. And was denied, but I've muddled along and applied countless times to for jobs at the philosophy department at NYU. Never so much as garnering an interview. So I don't think I'm ever going to get a job at NYU. So this is going to have to be it for me. Speaking with you today. It's an exclusion, that's true. It's true that it's exclusion. My backstory was not true. Okay? So I may have applied for a job at NYU at some point, I don't know, but I certainly didn't apply as an undergraduate or as a graduate student. And I want you to think a bit about what you were thinking when I told that story. Okay? Were you thinking, yeah, this guy looks like a tool, it's about right, I'm not surprised. Or, poor guy, right? He seems nice enough. Wouldn't it have been great if he had gotten in? I'm sure he's not that bad of a philosopher, things like this. Okay, maybe somewhere in this continuum, right? I suspect that none of you thought, what an egregious injustice. How could that? He had a right to be an undergraduate at NYU, and they denied. Where? What standing do they have to exclude him from their college? What standing do they have to exclude him from their PhD program? They didn't give him a job. They have to get, he's got a right to a job at NYU, right? So I'm guessing that that was not your reaction. If that was your reaction, this talk is going to have no purchase. Okay? What I'm doing for those people who've been here all day and paying attention, which is a lot to ask when you have to listen to four philosophers in the room. Okay? But it's a gross oversimplification, but I think I'm the anti-Michael. Okay, Michael started us off with a superb tone, where he said, hey, the good folks in Indiana in 1851 said, we're not letting any blacks in, right? And he expected us to think, that's a moral outrage. And then he flipped it on us and said, you better be careful if you're going to try and exclude immigrants from a country like the United States, you got to be careful that you're not doing the same thing that these citizens of Indiana do, right? I'm doing the opposite. I start off by telling the story about my rejection from, multiple rejections from NYU, expecting things, right? Maybe that wasn't fun for kids. There's no injustice there. They had every right to exclude me. And then I'm going to turn to states and say, why isn't it the same? What if instead of growing up, actually I did both. This is true. I was a Woody Allen fan, and I also grew up listening to Prairie Home Companion. And would always hear about the news from Lake Wobegon about the Norwegian dairy farmers up in the upper Midwest, right? So imagine that my fantasy was not to be a New York filmmaker, but to be a Norwegian dairy farmer, right? And I applied as an individual to be admitted to immigrate to Norway. And they denied me, right? Or maybe I went and became a philosopher and applied for a job at a Norwegian university, and they said, thanks, but no thanks. We're not going to let you in. Okay? What I'm going to suggest, I want to play with this analogy, and what I want to suggest is that you're right to be comfortable with my rejections from NYU. We'll figure out why, and then talk about Norway, and then time permitting, because again, I'm cognizant that I'm the fourth philosopher in the room, I'll take on some challenges to that analogy. All right. So I think we believe that NYU is entitled to self-determination. And part of that, an important component of self-determination, is freedom of association. And you don't really have freedom of association unless you are entitled to reject potential associates. Okay? So we're in NYU's law school. Some of you know that Columbia Law School is still reeling, right, from when Jeremy Waldron left Columbia Law School and moved over to NYU Law School, right? And the students at Columbia are very sad. So Columbia Law School comes to NYU Law School and says, why don't we have a program where any students we admit can take your classes for free and vice versa? Okay. Seems like an interesting idea. Maybe NYU wants to do it, maybe they don't, right? It's their call. Maybe it'd be better for the NY students or the Columbia students, or the world as a whole if they agree to this. But it's NYU's call whether or not they do it. Maybe Columbia as a whole, the entire university says, we're one of the best schools in the world, right? And you're one of the best schools in the world. Imagine we combined forces and became one university, right? That'd be amazing, right? Let's do it. And NYU says, well, think about it. Thanks, but no thanks. Right? It seems like, and this is to speak to the economists, whatever the benefits might be, right? Maybe it is true that it'd be better for NYU, or it'd be better for Columbia, or for both, or for the world if they merge. It's NYU's call. They are entitled to reject that association if they want. And even with Jeremy Waldron, right? Let's say Jeremy Waldron was and continues to be the greatest law professor in the world, right? Ever. Okay? Notice two things, right? It doesn't mean that if he wants to leave Columbia and come to NYU, that NYU has to take him. And it's certainly not the case that if NYU wants him, that Waldron has to move, right? Waldron, as an individual, has freedom of association. He can say, you know, NYU can make an offer which he's free to reject. All right? So if I was this incredible budding movie maker, NYU would have had a right to force me to come to NYU as an undergrad. If I was a particularly promising prospective graduate student in philosophy, NYU would have had no right to say you have to come here, right? The way freedom of association works, the way self-determination works, is you can have a permissible association if both groups agree to it. All right? Now turn to Norway. Norway broke off from Sweden, I think in 1905, 1906, right? So there was a separation. Sweden might say, we're doing all right, but we'd like to get back together. Let's reunite. It worked for Germany, right? Let's do it. Maybe it would be better for Swedes. Maybe it'd be better for Norwegians. Maybe it'd be better for the world if they got together, okay? Norway is entitled to accept or reject that association if they want, right? European Union. Norway is not a member. They voted at least twice on this, right? Norway has twice decided that they don't want to join the European Union, right? There's some of us who think that the European Union is one of the most important vehicles for the proliferation of human rights in the world, and that it would be stronger, right, if Norway were a member. And so it would be better globally for human rights if Norway were a member of the European Union. And so we wish that Norway would join. But we respect that it's Norway's call. Sweden doesn't get to forcibly annex Norway. Sweden doesn't get, and the European Union doesn't get to forcibly annex Norway. Norway has a right of self-determination, okay? So it looks like we think that institutions like NYU are entitled to self-determination, which includes freedom of association. And it looks like like Norway, legitimate states are entitled to political self-determination, right, which includes freedom of association. And so just as Norway may say no to Sweden, may say no to the European Union, and just as NYU may say no to Kit as an individual, Norway can say no to Kit as an individual, or Norway can say no to the individual Swede who wants to join the political association. All right? So that's the analogy. And then, of course, the inclination for anyone who wants to resist it is say, well, then the analogy's inapt. There are dramatic differences between either you trying to get into NYU versus you trying to get into Norway, or you trying to get into NYU versus some poor refugee, for instance, trying to get into Norway. So let me talk a little bit about it. So first of all, I think, notice the cost of saying that NYU is a dramatically different beast than Norway, right? I suspect most of you in your heads are thinking, yeah, it seems right, that, you know, it's Norway's call whether they want to reunite with Sweden, right? And it's Norway's call whether or not they want to be part of the European Union, okay? If so, then you're at least pre-theoretically inclined to believe that at least legitimate states like Norway are entitled to political self-determination. So there's plenty of fancy philosophical moves to resist that, but at least pre-theoretically, I think that is a good standard. I'm absolutely confident that freedom of association is an integral component of self-determination, such that if you're denied freedom of association, you're not fully self-determined, right? As Sarah mentioned, think about the marriage example, right? If your father gets to pick out your marital mate, maybe he's got good taste and he would pick out better than you would. Maybe you'd have a good life, right? But it's certainly not the case that you're self-determined, right? Because unless you have the right to reject potential suitors, in fact, all suitors, you don't have freedom of association and you don't have the right of self-determination, okay? So on that ground, I think we're good. And so then it becomes interesting if we start looking at different cases, right? And seeing if there are other reasons why, okay, granted, Norway has a right to self-determination, okay? But it's not an absolute right, it's a presumptive right. And when you look at the real world, it's got to be outweighed by more compelling considerations, right? So if Kit goes to University of North Carolina rather than NYU, just not that big of a deal, right? He's a middle-class, able-bodied white guy. He's going to be fine, right? We don't have real justice concerns about NYU excluding people like Heath. When we look at the horrific global inequality, right, such that the difference between people born in Norway versus people born in Chad, for instance, right, then we can't be so sanguine about Norway excluding outsiders. Right? So it looks like distributive justice, unless we just somehow fetishize self-determination, it looks like the global distributive justice is going to trump self-determination. Okay? I'm very tempted by this objection, but I think it's wrong. Okay? And to see that it's wrong, think about how we deal with inequality in the domestic context. Right? So we read headlines now about people like Jeff Bezos making $12 billion in one day when Amazon stock goes up. Right? And we might think, that ain't economic justice. That ain't right that he's got so much and so many of us have so little. Right? Do we infer from that that if anyone wants to, she can join Jeff Bezos' family? No. Right? If we think there's economic injustice, we think Jeff Bezos has to share that money. And as long as he distributes, right, the appropriate amount to others, as distributive justice requires, then he's entitled to maintain his freedom of association, right? So this is how we handle the domestic realm. We would never say the very poor get to join Bill and Melinda Gates in their family, right? We think instead, whatever the duties of distributive justice are, as long as people like Gates and Bezos distribute the money, then they're entitled to retain their rights of freedom of association. In other words, the duties of distributive justice and the rights of freedom of association are distinct and can be kept separate. So I think if we can do that domestically, we can do it globally, right? It may be that there is an unbelievably egregious injustice such that Norway has so much and Chad has so little, or the Norwegians have so much and Chadians have so little, right? But that doesn't mean that these duties of distributive justice have to come in the currency of opening borders, right? As long as the Norwegians are willing to distribute the funds in however justice dictates, then they would be entitled to keep their borders closed. What about refugees, right? Surprisingly, I want to say the same thing, okay? Refugees are absolutely, so Joe's talk was brilliant and heartbreaking, right? He's right that the status quo is a moral abomination, right? Okay. But it's not clear to me that the only way to fix this is opening borders. Okay, so if you have people who need refuge elsewhere, right, one way is to open your borders and give them refuge in your country. But what they're entitled to is refuge, right? Not necessarily immigration. And if you can give them refuge elsewhere, that's permissible. And it might even be preferable. Certainly if you can give them refuge in their home country, it might be permissible. Right? So there was a time, for instance, when Saddam Hussein's Ba'athist regime, there were worries that Saddam Hussein's Ba'athist regime was going to gas the Kurds in northern Iraq. One response would have been say, okay, all you Kurds, you're welcome to come to the United States. Another thing is to say, all right, we're going to interfere with Iraq and we're going to set up a safe haven with a no-fly zone to make sure that Kurds have refuge where they live. All right. Now, some people think that's better and that's preferable, right? I'm just saying it's permissible. You have to do something. You have to do your share on behalf of refugees, but that share doesn't have to come in the currency of open borders. Thank you.
So that we can have the Q&A. And I'll collect some, I'll collect 2 or 3 questions to begin with. Let me see if I can keep track. Yeah. Why don't you start, Michael? And I'll keep taking hands. Go ahead.
Thank you. That was just so fascinating. Each and every presentation, I'm going to be learning from this inside my head for days. I've seen expressed by Laura Lasky and maybe many other who questions the freedom of association argument, specifically because it inherently requires not just coercing outsiders, with people with guns standing at borders coercing outsiders and what are obligations to them, but also necessarily coercing insiders. That is, I know people with whom I want to associate who are unauthorized immigrants in this country. Some of them I want to employ, some of them I want to have social relationships with, and exclusion policy necessarily interferes in my freedom to associate with whom I want. Now, in the United States, since the Chinese exclusion era, there is no judicial review of legislative decisions on immigration. Congress has absolute sovereignty, cannot be questioned by the Supreme Court. That's the set precedent that remains to this day. Meaning that as long as there's a majority of people in this country who do not want to associate with a particular immigrant, they have absolute power to do that to me. And then is there no, as we discuss freedom of association, is there no concern about the 50.1%, or maybe in the last election, or like 48%, 47%, being able to impose their view on me of who I get to associate with? This could be a problem that all of you have already solved, and you're sort of smiling inside at what this account is thinking about. But it's something that I haven't been able to resolve for myself, and I really like some help.
You could take one other question. Michelle, do you mind?
Yeah, so my question is for Sarah. I love this panel very much too. And it's about the notion of culture that might be at stake in the idea of cultural impact. So two worries. Might you be presuming that there is a thing called culture, that cultures that are more neatly bounded and separable from each other than they really are, and maybe more internally integrated than they are, not recognizing that sometimes cultures do best when they acknowledge that cultures are in fact usually hybrids of the interactions that we have with people in other groups. And my worry is that the idea of cultural impact might be used to actually be damaging to the local culture, but also as a kind of weapon when the thing you're using as a weapon, not you, but one might use, might in fact be much less precise entity and separable entity than your view suggests.
Sarah, do you want to start, and then others might want to jump in response to Michael's question?
Okay, yeah, I'll start with that question. Thank you for that question. Yeah, so I spend a lot of the book criticizing the cultural argument for the state's right to control immigration, and precisely for the reasons that you articulate. That I believe that cultures are hybrid and pluralistic and not neatly bounded. So I would want to scrutinize how the cultural impact argument is used in regular political discourse about, it's going to irreparably harm our way of life. And so I think the question, we can look at concrete types of policies like language. We want to preserve the French language in Quebec. And so this is a relevant consideration when we have debates about who Quebec should be required to let in and preserving the language. And so I think that would be a really important, but I would want to scrutinize, because often these thinly veiled or not so veiled cultural arguments are really about racial arguments, about not wanting members of X group. And so, and I think those are reprehensible from a liberal democratic point of view.
Okay, do you want to answer
Sure. So Lauren's right. Partially. There's a conflict. So you can't have collective freedom of association and individual freedom of association. One's got to prevail. As you mentioned, our legal precedent is that the group always prevails. If you're an unflinching libertarian, it's going to be the individual who always prevails. I'm inclined toward neither. I think it's an open case. And what I'm inclined to say is that in most cases, it's the collective, and you have to give the case for why collective self-determination is so important of freedom of association. But that doesn't mean it's always going to prevail. And one exception, as a couple of the panelists have noted, is very likely to be family reunification. If you've got family members, their freedom of association, it seems to me, is going to be more compelling than the groups. And so that would be a case, not speaking legally, but morally, where I would say the individual freedom of association should prevail over the collective.
Giovanni.
So I want to follow up a little bit on this, for the rest of the panel too, on this, which is the libertarian view versus the government or the state has a similar right to the individual, which is at the opposite. Isn't it logical that some of these freedom, if they are rooted in the individual, if we think they're civil rights, they're going to be rooted in their, the bigger the group becomes and the fuzzier its role becomes, the less should be attributed to that entity interference and prevalence on this. So as you said, the family, no, but say that you had given another example, which is, I was admitted in NYU. NYU really wanted me, but I was a foreign citizen, and the US government told me, nah, you come from a country that is not the right one. How would you react to that? So this is a contrast between a more, or you were hired by a firm in the United States that wanted you as a worker, a corporation, a company that really wanted, and the US says no. So government put in a lot of exception to try to deal with this, because though ultimately it seems to me that there is a fundamental problem. And finally, the thing that I want to add to this is that some countries limit the internal mobility of their citizens. So China puts massive restriction on where their own citizens can go. At least it did, it's changing a little bit. And we consider this as a big intrusion in the freedom of individual. In fact, a lot of states have freedom of mobility within their country as something that is in the rights of the individual. So why? Why do we have this break? And the European Union that you mentioned, the European Union is a step. So should the European Union now decide who they want Europeans to associate rather than individual government? When you go to this aggregate institution and you put a lot of power in their decision, it seems to me that you hit a lot of complicated issues, and the prevalence of the individual or the small unit seems to me in general a good principle. What do you guys think about this?
So, Joe, since you haven't spoken yet, either of you.
There are people who are kind of libertarian individualists. That's all that matters. That's not my own view, actually. I'm quite sympathetic to the idea that collectives matter and collective identities matter. But the issue is how one decides the relative claims of the collective and the individual. And it seems to me that one of the difficulties with some of the arguments here is that they abstract from the existing realities. So imagine a world. So it seems to me that if one wants to, as say Sarah was doing, about collective self-determination of a people, you can't abstract from the relative relationships among peoples today, their relative positions in the world, and talk about whether or not you think that overall organization is itself justifiable. So now Kit was going to address that by saying, well, we will, you have to provide something for the others. So take the issue of internal mobility that you mentioned. That's constructed in international human rights documents as a fundamental human right. It's not a right of citizenship. It's a right for any person who is within a country has the right of free mobility within that country. Well, why would that be in an international human rights document? It's because it's the freedom to move freely for an individual to move freely within a territory is seen as something fundamentally important, even though the states, like as China thinks it has good reasons to want to restrict mobility for the benefit of the society as a whole. The argument is, no, this is one of these things that ought to be more important, that you ought to respect. So once you see that kind of moral claim, so I'm not an absolutist about anything, including freedom of movement, but it seems to me the general claim ought to be, just as we have strong reasons to believe that freedom of movement within a country, within normal constraints about public order and so on and so forth, is to be regarded as a fundamental right to be restricted only in severe circumstances with exceptional reasons, so too movement across borders ought to have the same sort of status. And that would be true even if the background economic circumstances that make movement so urgent. So my ideal is not a world in which millions of people are moving from one place to another. My ideal is a world in which everybody is happy, has the opportunity to have a good life at home. Some people, but everybody is free to move. And the fact that they don't is itself an indicator of why the background arrangements are just.
Leo, do you want to?
Thank you. So this question is for Sahar and Sarah. Both of you mentioned political communities and mentioned analogies to families. So a marriage, for example. So this was a question about the definition of political communities and the analogy to families. So Sahar mentioned marriage as an analogy case, and then Sarah mentioned some of Michael Walzer's work about a national family. So if we look at the history of how the political community, for example, in the US formed, it's rare to think of an analogy to a family or a bloodline or an ethnicity. So I wonder how this concept of a political community differs in a country that has a history of immigrant settlement.
So I'll quickly answer that because I think I have a fairly brief response to it. I didn't mean to suggest that states were like marriages. I meant to suggest quite the opposite, that they were not based in family relationships. They don't have the same kinds of interests at stake in selecting members. So I do think it's a very good question, though.
So I brought up this notion of states are like a national family in discussing Walzer, and he has this terrific line, Greeks driven from Turkey, Turks driven from Greece. What are states for but to sustain culturally distinctive ways of life? That these peoples or these cultural families are searching for political forms to sustain their way of life. And I think you're right, that runs up against, there are different traditions of conceiving of political community. And in the US, I think we fancy ourselves to be in the more civic tradition that is non-ethnic, that's really based on shared values, shared principles, the Constitution, and more pluralistic in that sense. And I think that's the ideal that I think we should aspire to. In reality, we've had racial, ethnic, right, that those have been very constitutive of the identity of the political community. And I think that we want to continue to aspire to something that's more ideals-based. But yes, absolutely. I think that that's one of the problems with embracing ethnic-based conceptions of political community.
Jennifer Hunt.
It seems to my philosophically poorly trained mind that the arguments based on self-association, they seem to assume that we know what the unit is that's self-associating, whereas national borders, both arbitrary and recent, you were actually just talking about Greeks going to Turkey and vice versa, that would just be one example. So I guess I would like to ask Kit why we're confident that current national borders enclose the right groups that have the right to freedom of association.
I can't speak for we, but I can say I am not confident. Yeah, I'm not defending the status quo. I'm not saying existing states have the right to exclude outsiders. I'm saying legitimate states are entitled to self-determination, one component of which is freedom of association. I feel pretty confident saying Norway is legitimate. And so I'm happy to use the example of Norway and Sweden. There aren't that many states I'm that confident, right? So is the United States legitimate or not? I'm not sure. If I'm in Vegas and you make me bet, I'd bet not. And I can give you my reasons, right? But yeah, so I'm not defending the status quo, and I'm not saying every state that happens to currently exist is entitled to political self-determination.
Yes.
So I wanted to follow up a little bit with Kit in terms of the question of refugees and how you deal with refugees. If one of the important principles for a nation state is self-determination, and the way in which you exclude refugees is to provide some other alternative, then by definition, aren't you deciding for someplace else how those refugees will be handled? And denying that other location or nation some degree of self-determination because you have placed your own desires of exclusion above their determinations or their inability to deal with the refugee situation. And then for Professor Song, for Sarah, how, again, I keep coming back to how do you define culture? As a institution that sometimes draws political boundary lines around the concept of a community of interest, it's very, very permeable. It's variable. And it's sometimes self-defined and sometimes not. The thing about ethnicity, race, religion, and why they keep on, I think, coming back to haunt us, is that in most instances, not exclusively, but primarily, they are objectively determined. You either are or are not a Catholic. You either do or do not have that skin pigment. You either do or do not have blonde hair. And whether you share a cultural basis is something which is much harder to determine and changes over time. So I challenge the idea of using culture because all too frequently it becomes a substitute for what we don't want to admit, which is our reliance too frequently on race or other, quote, objectively perceivable factors.
So the notion of culture isn't that important to the moderate cosmopolitan view that I want to espouse. I think what's getting me into trouble is that last slide where I said cultural impact. I think that we need to demand specificity when someone says, oh, I'm really worried about the cultural effects of this kind of immigration policy on our country. What do you mean? Are you talking about impacts on the language? Are you talking about religion? Are you talking about what kind of restaurants we can have in our neighborhood? That we need to demand specificity and we need to smoke out the kind of racial assumptions that might be embedded in some claims about the so-called cultural impacts of immigration.
Or economic assumptions.
Okay, so the truth is that there's not as much space between Joe and my views as you might think, but I recognize that I was invited here not to minimize the space between Joe and me, but to emphasize it, that I am, you know, if you're going to have Joe, you got to, you know, wheel out Michael Blake or David Miller or Kit Wellman, right? And so that's my role, and so I tried to emphasize the differences. So let me, but I'm not taking back anything I said. I believe everything I said, but so let me say, okay, so Joe and I agree that Norway, that the status quo is unjust, right? And that Norway's not doing enough. That's where we agree. Now, please understand, I'm not exhorting Norwegians, don't let anyone in. I'm not anti-immigration. I think the world would be better with more open borders, right? And I would urge legitimate states to have more permissive immigration policies. But what I do emphasize is that legitimate states get to make the choice. It's their right, okay? So I say of Norway, you're not doing enough. You either need to open your borders to your fair share of refugees, or you need to help refugees in some other ways. It could be preemptively. You could have done all kinds of work to make sure that people didn't become refugees. It could be you give people refuge elsewhere. It could be that you pay another country an enormous sum of money from your North Oil Fund, right, so that they'll take them in, okay? There are any number of ways that you can pay your fair share, all right? Now, you say, well, if you're letting Norway make that decision, isn't that undermining the self-determination of others? I don't think so. It's dramatically impacting other people, but I don't think it's denying them self-determination, right? So if George Clooney were to propose to me, right, it dramatically impacts him whether I accept his hand in marriage or not. Okay? But if I say no, I'm not denying him self-determination, because his right to self-determination does not include the right to have me in matrimony.
The gentleman in the back, yes.
Sahar and Kit emphasize collective identity and freedom of association. Clubs can expel undesirable members. So wouldn't your position justify states expelling undesirable natives?
Yeah, this is my problem, not hers. I'm trying to let my panelists get in, but this is really my problem. Yes, I'm not against divorce, and I'm not against clubs expelling members. Now, the interesting thing about states, right, is that states have to operate in a way that respects the basic rights of their constituents. So we talked about free and equal. I think Norway has to ensure that all Norwegians are treated as free and equal, right? But that's very different from saying Norway has to treat all citizens as if they're free and equal. And one important right is an occupancy right, all right? So Norwegians don't get to say, of people who have an occupancy right, we're going to form the state here, and we're going to decide these are the characteristics we want. You don't have this characteristic, so you don't get to be in the group, and you can remain. Because you can't have second-class citizenship. If they're going to remain, they have to be full citizens. So then you want to say, okay, well then you just have to get off of our territory. But if they have occupancy right, you can't ask them to leave. So Norwegians have no choice but to treat everyone with occupancy rights in their territory as free and equal citizens.
So I have a bit.
Follow on this. Can I add? So can you comment on the opposite, which is we admit people in different ways in different countries, either because they're born there or because their parents are in there, and they don't make any choice of being in. What's the right way of admitting in the club that is a country? Do you have a preference?
I certainly have preference, but I think that legitimate states have wide discretion, and they would be not violating rights if they weren't as permissive as I'd like them to be, or they use different criteria. Now, one of the things that came up with several of the panelists is what if they exclude based upon ethnicity or race or things like that? That, right, from our very first talk, looked like it's got to be wrong. And there may be limits on the criteria that can be used. But my view is that there's still room for broad discretion within those limits.
Can I just say something briefly about, notice Kit's references to legitimate states presupposes the legitimacy of the international order in which those states are existing, and that's precisely what I want to challenge. So that's one of the key differences between us.
So I was going to say we have officially only 5 minutes left. I think we can go over that a little bit since we started slightly late. Just going to sort of unilaterally decide this is fine. But I do have at least 4 people on the list, so I'm going to suggest we combine 2 questions at a time. So how about Alden and then Bill Easterly start, and then after that I have Terry and Jess. Alden, do you want to start?
Thank you. So this question is for Sahar and Kit. So I thought I heard a account in Sahar's talk that could maybe be used to attack the analogy presented in Kit's talk. So I'm not sure about the thing about power, but there was this idea of certain associations having interests, and we think it's okay to discriminate in who you marry based on all kinds of demographic categories like gender and sex and maybe sexual orientation, and that's totally fine because they are relevant to a legitimate interest of a marriage. And so I was wondering if you could say that NYU could exclude you because it has a legitimate interest in a high caliber student body, but that countries can't exclude.
Real nice.
Countries can't exclude members based on race or religion if it's not if they don't have a legitimate interest in racial homogeny or religious homogeny, and so that they can only exclude, and they can't exclude them based on reasons that aren't or that are totally arbitrary. And so that they have to give a justifying reason in terms of a legitimate interest. I'm not sure that would be counter to what you think, Kit. I'm just curious if that would be something either of you would be friendly to.
Well, I'm curious as well.
So do you mind if we just take the second question first?
Oh,
and then
sorry.
Bill.
Sarah, you mentioned in passing development assistance as kind of a compensation for restrictions on migration. And then Kit, you mentioned outside military intervention, such as with the Kurds in Iraq. And this is a very popular argument right now of development assistance and intervention, so-called humanitarian military intervention, as a kind of compensation for restricting migration. The problem with it is, first of all, migration is empirically far more effective at achieving gains in material income and freedom from violence than those two options are. And second, both foreign aid and military intervention don't have a good mechanism for sort of consulting the preferences or the wishes of those that they're intending to benefit. So basically, you're taking away from people something they do want, which is to migrate, and giving them something they have not been consulted on and did not ask for in the form of military intervention or foreign aid.
Who wants to start?
So thank you for asking a question of Kit that I also want to ask. So you said that you sort of agree that racial and ethnic exclusions are off limits. Why just those two? Could you say a little bit more about why you think those are the relevant constraints on freedom of association and not, say, skill-based or gender-based constraints?
So I don't agree. I don't know. So the way this debate goes is that there are two individuals, Michael Walzer and Joe Carens, who were way out in front of everybody else, right? When no one was considering these things. Walzer in Chapter 2 of Spheres of Justice says, membership is hugely important. Here's what I have to say. And it might be right, it might be wrong, it's brilliant, okay? But one of the things is he talks about white Australia. And he says, white Australia has a choice. They can either cede some of its territory and become little Australia and remain white, since it doesn't need all the territory, or it can open its territory to non-blacks. And everybody in the discipline went, right? Really? Really? You're going to allow a little white Australia? And that was my reaction, like everybody else's. What has ensued is a lot of people, including Sahar, saying, all right, this is really tough, actually. And so I would be thrilled if someone could come up with a conclusive refutation of Walzer. I have no interest in defending white Australia. What I've come to in thinking about this is that he's actually, he might not be wrong. That doesn't mean that NYU can exclude blacks, right? So I'm confident in a footnote in Joe's paper, he talks about, well, you've got a conflict between freedom of association and something. And I think he's right into, it's probably equality. It's probably equality. It's always equality with Joe. Okay, so what you have is the United States has a requirement to treat all of its, to ensure freedom and equality amongst all of its citizens. And given the horrific racist injustice, we can't let powerful institutions like NYU exclude people on the basis of race. That's absolutely right. Whether that extends to states is less clear.
So I do think, so I want to just raise a potential objection to what I said about the analogy from the domestic context to states, and then say something in response to Kit, if I can. So a potential objection to what I said is, well, look, the reason why businesses have obligations to non-members not to discriminate against them is because they share the same society, and as such, they have various kinds of egalitarian or other sorts of obligations to them, including not to deny them on the basis of traits like race. But we just don't have those sorts of obligations, or states don't have those obligations to people outside of their states. And I think what's actually required for saying that we must not discriminate on the basis of characteristics like race is not really any kind of robust egalitarian machinery. We just need to recognize the basic moral personhood of every person. And I think this is something I'm not suggesting that states have the robust distributive obligations. I do have some thoughts about that, but I haven't said anything about that. And we don't need to invoke that entire machinery, I think, to say why it's wrong that states may not select on the basis of traits like race. And Kit, my understanding of your view is the reason why states must not do that has to do with respect and regard for their own citizens. But that just, to me, can't be the right explanation. The right explanation has to be something about what they're doing to the non-members.
Good. So it looks like it's at least one thought too many. Are you kidding me, Kit? You've got to resort to this elaborate thing? And the reason why I do think you need an elaborate explanation is precisely what you acknowledged. Oh, when it comes to romantic relations, I agree it's deplorable if somebody wants to reject a potential suitor on racial or ethnic grounds, but I'm not sure it's a rights violation, right? So if, like me, and I think like you want to say, deplorable but not a rights violation if somebody excludes romantic partners based on ethnicity, right? It is a rights violation if an institution like NYU, within a context of historic and ongoing injustice, racial injustice, excludes based on race or ethnicity, right? Then you want to look at the arguments. You have to do the extra thought, which may strike you as one thought too many, but the extra thought to explain why it is that NYU may not. And every time I look at those extra thoughts, they don't apply, or at least they don't apply neatly to states.
Did one of you want to reply to Bill's observations?
You go if you got it.
Yeah, sure. I don't know if I got it, but I'll try. So, yes, development assistance is second best or not very good, and that we lack institutions, for example, if we give foreign aid, and so why not? I think that open borders is also second best. I think what I'm trying to argue is that we have membership-based obligations, but we also have global obligations, and then the question is, what are the best mechanisms or ways to discharge our obligations to all of humanity? But I do think that immigration restrictions are tied to genuine efforts to improve the conditions of those outside our borders. And so it's helpful to hear from economists that development assistance is deeply flawed. But I also worry that open borders, are there economic forecasts of who would move and would it really genuinely help the most destitute and the worst off? That also seems to be a less than ideal solution. And so we're left with all of these second best or third worst or options. But it is something absolutely that the normative argument hinges on there being effective ways to actually discharge our global obligations. And right now we're in a muddle.
So Terry and Jess, can I ask you to both be really quick? As quick as you can be.
Okay, so for better and for the best and worst of reasons, I'm going to get specific instead of generalist. And part of I hear a strain to try to be universal. I want to be very specific. For very good and very bad reasons, we created a multicultural country. It is not going to alter the nature of the United States for any immigrant to come. That is the basis of what we exist. We also did some terrible things, right? Slavery, the Chinese Immigration Act, turning away the St. Louis. We agreed as a society that these things were wrong. Does it not create an obligation upon us to keep our borders as open as possible, because it will not alter us and we have an obligation to right the wrong that we committed as a society?
Jess, do you want to?
I have a question for Kit about Norway and Chad. It seems to me you raised the issue of immigration versus redistribution, and one way to right immigration is to undertake redistribution. And they are, of course, related. They are both economic questions, and they are questions of economic justice. So if we look at it this way, how much redistribution do you have in mind? It would have to be a lot. If you redistribute enough, nobody in Chad will want to go to Norway or the other way around. Everybody's happy where they are, but that will take a lot. And if you were to do that or even come close, wouldn't you be infringing on the rights of the Norwegians, who would have to give a third of their GDP now? It's inconceivable. They might claim that you have, in fact, inflicted much more damage, just as much damage as immigration would, and destroy the economic basis of their society. So replacing immigration with redistribution is like this two sides of the coin. I wonder if, aren't you maybe under an obligation, if you're going to say no immigration but redistribution, to explain how much and to get into the details of it?
I think I can quickly and unsatisfactorily answer all three of these. So even if we assume that the United States is a legitimate country, there's no question that it has massive remedial obligations based upon the injustices perpetrated. It's a secondary question whether those obligations have to be paid in the currency of open borders. I don't know what precisely the demands of global distributive justice are, right? And I'm sorry to disappoint you. My claim is going to be whatever they are, they can be paid either with open borders or otherwise. Oh, but the otherwise doesn't work, all right? So you can't do that. Having just publicly taken a stance against Carens on immigration, I'm not going to go toe-to-toe with Bill Easterly on what kind of foreign aid works. I'll just concede this. I do have same concerns that Sarah has, but I'll just concede this. My argument is contingent. If you can give people refuge, satisfactory refuge elsewhere, right, or in some other way, then you're permitted to do it, right? If it turns out that fancy folks like you show that in this case, or in many cases, or even all cases, the only way you can make sure their human rights are satisfactorily protected is by allowing them to immigrate, then they have a right to immigrate.
Anybody else wants to have a final word?
I like the way he ended.
All right, good. So, in that case, please join me in thanking our speakers.